I'll call to order this February 26, 2020 continuance of the Seattle Waterfront LID assessment hearing. Today, objections will continue to be heard for hearing examiner case numbers 336, 337, 339, 340, and 342. First, I need to address a motion to compel discovery from another party with the city, and I've got the motion. It's been forwarded to the city, so we'll have some discussion on that. It's something I need to take out of quick order due to time constraints. We'll take a break today at 10 a.m. I'm not sure how much longer we're going to go, but we'll plan on taking a break at 10. Please make sure your cell phones are off and not on during the hearing. And we've had a little problems with our court reporter, so I need to remind everyone to speak one at a time, and for purposes of both recording and the transcript. And particularly for the audience, no talking. All right, let's turn to the motion from Mr. Victor Moses, and that is case number 375. Mr. Moses submitted an email that I'm considering a motion, in part, a motion to compel discovery for participation in a deposition. I believe Mr. Moses is here today. I've heard your argument in the email, so I don't necessarily need more input from you on that. I understand what you're asking. The city, typically when there's a motion, there's an opportunity for response, and of course in the short timeliness, the city doesn't have a time to write a response, but what I understand from the email motion is that Mr. Moses, that I haven't been participating in depositions, but I understand that at least he's stating that there's been a deposition scheduled for tomorrow, February 27th or maybe the 28th, that he's had some communication with the city about that, that there was some indication that he would not be allowed to participate, that I do recall from February 4th that he asked about it, although he was directed at that time that, along with all other parties, that they needed to handle discovery on their own, because I was not ordering any discovery at that time until I got a motion like the one I've got in front of me now. He does state in the email that he wants to be allowed to depose Robert McCauley from the city, and that he anticipates he may have an expert, but he doesn't know. So that's what I've received in the motion so far. And if I can hear from the city.
Yes, we have been in contact with Mr. Moses, and our understanding from him is that he has since retained Peter Shorett as an expert witness, and the city's position, as stated on February 4th, was an objector who is putting on an expert witness of their own would be entitled to depose the city's expert. You know, having understood now that Mr. Moses has retained that expert, we have no objection to him participating in the deposition of Mr. McCauley, which is scheduled for one day beginning tomorrow. He will, need to work out the details of his participation with the other objectors who have been working with city's council to schedule that deposition.
All right, it sounds like I don't necessarily need to make a ruling on that portion of what he's requested then. I will simply comment for the record that the city's approach to handling the deposition is similar to what the hearing examiner will do for cross-examination. I hope to have an order out later at the end of this week, if not maybe next week, concerning cross-examination of the same witness. While there's an opportunity, a general opportunity afforded in a assessment hearing to cross-examine witnesses, in a case here, there's also a burden on parties who are objectors to put on a case. And where we have 400 objectors, some are certainly putting on a case. Some are planning to do that, and they have a right to proceed with that. Others who may be seeking to cross-examine but simply haven't put on their case will not even be afforded an opportunity to cross-examine. They've submitted a comment, they've submitted an objection, they've got a right to do that. But if you're not, you can't. What I need to avoid is 400 people saying I have a right to cross-examine the city's appraiser because I want to cross-examine, and that's how I'm going to put my case on. That's not how to put your case on. So if you need it as part of a case, it's going to be afforded as an opportunity. And I'll describe that in more detail in my order, but it be approached in the same manner as well with timing. There's been 2 days set aside for cross-examination. Here there's been a opportunity for deposition that, frankly, in being granted is extraordinary, maybe not extraordinary and huge, but certainly out of the norm in the sense that for assessment hearings it's not common. It's not unheard of, but it's not common. And in this case, the requests for depositions all came in after the start of the hearing as well, and they should have been addressed and scheduled before the hearing even started on February 4th. So the opportunity that the city is affording and providing at the hearing examiner's request is generous, and they've set aside a day to do that. They took the examiner's direction to act in good faith, and they did. They set aside a day for that. That's the time that's been allotted for this deposition. It will be up to the objectors to organize their time within that, who's going to get to ask questions and such. I certainly will not entertain any motion to extend the depositions beyond what's already been scheduled. That's a good effort already, and that's all for the purpose of preparing for cross-examination for those parties that will be participating in it at the end of the hearing. I think we've addressed that matter, and so I understand that you'll be participating tomorrow.
May I make a comment?
What's it regarding?
It's just regarding scheduling. My expert has informed me that he will not be available on the 10th. He is already scheduled to testify on either the 12th or 13th for Perkins and another issue. And so I would like to submit, I will provide the report. We will have time to get that done after deposition, but that we could delay his testimony until sometime on either the 12th or 13th when he's here. And you'll have time to review the report. If you have questions for him, you can ask them at that time. And I don't think it's going to take more than 5 or 10 minutes for him to make his comments.
So what I understand from Mr. Moses' comments is that he has been scheduled for March 10th. The only objector to have been scheduled after the fact from February 4th when I said it was cut off, but I understand there was some confusion on his part on how this works. So he's been granted a date for presenting his objection on March 10th at 1 to 2:30, accommodating the time he's requested, and that he does indicate that he's got an expert witness who will be appearing for another case on a different date. And so for matters of efficiency, which we've seen similar to Mr. Williger's, there's some work, which I appreciate the objectors engaging in to work together, so we have some efficiency having a single expert appear at the same time. And so the city will have an opportunity to, the objectors will have an opportunity to have their, and I'll state this now, that your hearing essentially will be continued from the March 10th date to when your expert appears for that limited purpose to have that additional testimony provided by your expert. And similarly, the city will have an opportunity at that time to cross-examine not only on the case at hand that he originally shows up for, but any comments he makes on your case as well.
Thank you very much.
Right, I
I
think we've,
appreciate the city's
wrapped it up.
cooperation in this.
All right, let's proceed then with objectors.
The objectors call Melody Lanthorn. Sorry, you're just gonna sit right there.
Morning.
Morning.
Please state your name and spell it for the record.
Melody Lanthorn, Melody Lanthorn.
And do you swear or affirm that the testimony you will provide in today's hearing will be the truth?
Yes.
Thank you.
Good morning, Ms. Lanthorn. How are you?
Morning.
Good. My understanding is that you are the general manager of the Courtyard Marriott in Pioneer Square. Is that right?
Yes, that's correct.
What are your responsibilities?
I oversee a $20 million business for the operations, the sales, the facility management, the entire facility
And how long have you held that position?
for 1 year.
And do you have personal knowledge of the hotel's operations and their clientele?
Yes.
Okay. How many days a week do you work in the hotel?
5 to 6,
How many,
sadly.
How many years have you been in the hospitality business?
I've been with this current company for 32 years and 37 years total in the industry.
Okay. Are you familiar with the city's proposed improvements to the waterfront?
I am.
And how are you familiar with them?
I sit on the board of directors for Pioneer Square Business Alliance, and they've had a guest speaker come to our board meetings to present the waterfront changes.
And have you seen drawings or outlines of maps showing where those changes are going to be made?
I have.
Do you believe the Courtyard Marriott is going to enjoy any special benefits from the proposed improvements?
No.
Why not?
I think that it will create more traffic, and there's already a lot of traffic and confusion on the streets down there. I also think it will take away from the resources that we have for the public. Right now, the parks that are around our current property aren't very well maintained or taken care of, and they have people hanging out in them that doesn't necessarily bode for attracting additional business. So I really don't think that having yet another large park near us will help us. Our customers don't come to really visit the parks. They usually are here to go to a convention at the convention center, go to their office building. A lot of legal business comes our way because we're close to the courthouse. We're also close to the stadium, so we get a lot of people for that, but we wouldn't necessarily have somebody drive in to go to the park, so it won't generate additional revenues or help build our room rates up.
So will you be able to increase your room rates after the LID improvements are completed?
No,
Do you expect an impact upon your occupancy?
no.
Can you give me a breakdown of what sorts of guests come to the Courtyard Marriott, just generally corporate versus other kinds of
Yep,
guests?
so we're very seasonal, but if I was to say annually what the percentage of business is, it's about 45% business travel, 20% a group or convention type business, and the balance of it would be leisure, meaning that you're maybe going on a cruise or you're here to go to a concert or a football game, something that's happening at the stadiums.
Does the Courtyard Marriott advertise proximity to the waterfront?
We do not.
Do you advertise proximity to other locations in Seattle?
We do.
And can you give me an example of some of those?
The Chihuly Glass Museum is on our website. The Seattle Center is on our website. The stadiums is on our website.
And do you think your guests are influenced by the proximity of the waterfront?
No.
Do you know whether the LID improvements will be visible from any of the rooms at the Courtyard Marriott?
They won't. I do have, so we have 262 rooms, and about a third of my inventory has a view, a really gorgeous view, but we don't quite see the front, even with the viaduct down. Can't even really see the ferry terminals, but what we do see are the ferries pulling out, and we can see West Seattle, and we can see out in the Sound, but we can't see right along the waterfront.
Okay. And you touched on this briefly, but can you tell me, do you have any concerns about the proposed improvements to the waterfront?
I guess the concern that I would say I would have is that right now we have a lot of disturbance around our building, and we don't have the support that we would like to have from the city, from the police department specifically. So we have a lot of havoc with people trying to get in the building that don't belong in the building, people trying to use our bathrooms that aren't guests, and drug use in our back alley, as well as prostitution and drug sales. So typically when we call the police, we call when it's really important. We don't just call because we would be calling every day, but we call when one of our associates is in harm's way or a guest or we have somebody in the building, but the police response time is poor. It varies between not coming at all to 45 minutes to an hour and a half. So recently we had an altercation with one of our associates and the person ended up being taken away in an ambulance, but it took an hour and 20 minutes for the person to get here, and I did have security personnel on, but we couldn't remove the person from the building.
And you mentioned security. Does Courtyard Marriott employ security or any other, made any other investments to address your existing concerns?
Currently, we have a security officer on site from 3 p.m. in the afternoon until 6 o'clock in the morning. I am considering going to 24 hours just because of the changes that have happened and some of the things that have happened with our associates. We did just install the associate alert device, which is a new law that happened in January. So each of the people that work in a private area or an area where they might be encountered by somebody who was threatening a non-guest, they have a little alert button that they can put, and that was $30,000, but that's a law, so we would have done that whether or not we were in the neighborhood. We also we are in the process of installing $46,000 worth of fencing to cover up a stairwell that we have that's a fire exit, but we're going to put a big gate over it because right now people go down the steps and they use drugs and do bad things down there. And then we also have an alcove where people sleep, and we're going to gate that off. And then I just installed razor blades at the top of our back loading dock because we've been having people jump over the fence to steal our food and beverages when they are getting delivered. Like the delivery truck will come and there's like a 5-minute gap between our staff being able to get down there. And so we've been having people hop the fence, throw like a case of orange juice back over the fence and then run with it. So those are some of the things that I've encountered in my short year at the property.
Do you or your staff provide direction to guests who are interested in taking a walk or taking a run in the area?
We do, but so other properties I've worked at, we have running maps, and you would just say, here you go, guest, but at this property, we have chosen not to have running maps because we don't want any liability if anything was to happen to someone. So we usually suggest they use our fitness center as a first call of action if they're looking for a good workout. If they are going to go on a walk, we just advise people to be careful.
And do you anticipate coming up with a running map or making any changes to that practice after the lid improvements are completed?
No, not at this time. I mean, that's a ways off, but not right now.
No further questions.
Good morning.
Morning.
So you were just speaking about the issues that you've encountered in your year at the hotel. How do you think that the lid improvements would affect those issues that are already existing at the property?
I think that unless the police department gets bigger, that they'll be even more stretched. So I feel like if there's problems that are happening down in the waterfront area, then that's one less police officer that can come help us when we're in trouble. Like I've been to the police department twice since I started working here because we pay our TOT taxes. And we write a check for close to $2 million for the TOT taxes, but in turn aren't really getting the services of support back. The fire department comes really quick if we need to call them, and that usually is only because if we have rarely like an elevator issue, the fire department is immediately alerted to that. But with the police, that's a different kind of thing. So I think the park could take away from our support that we have unless part of that includes additional staffing for the police resources.
And just for the record, what does TOT
Oh, I'm
stand
sorry.
for?
Tourism, it's a tourism occupation tax. So it's a percentage of revenue. So in a peak year, our hotel did $24 million of sales, total sales, including rooms, meeting space, restaurants. And 10% of that goes to the city as part of the taxes that were assessed as being in hospitality. And those are usually, in other cities I've worked in, they go to the fire and the police to help pay salaries.
And so you just mentioned a $24 million sales revenue in a peak year. What year was that?
That was in 2017.
Okay.
Since, this past year, there was 24% new supply that opened in Seattle, which has made a lot of havoc on our sales. Our occupancy is still very strong, but it's hard. There's a lot more competition, so rates have eroded. So this past year, we also had a renovation impact a little bit. We only did 17.4 million, and this year we are forecasting and hoping and budgeted to do 18.2 million. But our room rates are $25 down over our peak years, while our occupancy is pretty flat. That big Hyatt, that's a lot of rooms.
And those figures, those dollar figures, that's just revenue in sales. It doesn't, does that account for expenses?
No, that's not profit.
No. Okay.
Yeah, no.
Net.
Yeah, that is just straight sales. So then there's the labor, which is our top cost, and then there's heat, light, and power. There's insurance premiums, and then there's all the minimum wages that are very high in Seattle. So the profit levels at our courtyard aren't at the same levels of courtyards that I've worked at in other places, specifically in California, because of the high hourly rate that we pay, which I understand this is an expensive place to live. I get all of that, but the profits just aren't as grand here.
And are you aware whether the courtyard has hired an appraiser to appraise the property in connection with the lid hearings?
I wouldn't know. I'm in management, and we're a paid operator to run the building, but our ownership group, most likely, if any of that happened, would do that. So Marriott's a management company. We don't own things.
Okay,
And that's who I work for, is the management side of it.
thank you. No further questions.
None from me.
Thank you.
You're welcome.
What do we have next?
We have a SEPA presentation, Your Honor.
Okay.
SEPA presentation, S-E-P-A.
No, I couldn't hear you.
Oh, you could hear me.
I could not hear you.
Okay,
You were
sorry.
facing the other way.
I'm trying to remember to just look straight ahead that way, maybe.
Good morning, Mr. Hearing Examiner Duwana
morning.
Koloshkova. Present on behalf of the objector speaking this morning, and if I might have a moment just to get a little
Please.
organized, I'd appreciate that. Thank you.
The big one, I think, for you is this number 60.
I've got 60.
The fourth box.
Any of these. Thank you, Mr. Hearing Examiner. And
Oh,
while
yeah,
I-
these are marked but not admitted, yeah.
Okay, thank you. While I'm coordinating with my co-counsel, if I may, I'd like to introduce myself and explain my role in this matter. I have been retained by what I'll call the set of objectors. Am I being picked up well enough on this mic? Oh, I mean, for your purposes.
That's not the mic.
And this isn't the mic she's listening
This is not the
No.
mic she's listening to. That's
Yeah.
what I needed to
There's
know.
two
Thank you.
There are two recording systems. We
I-
have our own resource system up here, and then we have the transcriptionist.
Thank you. And yeah, I tried to get here early enough to kind of figure out how the acoustics are in
Right.
here, but
Not so good.
no worries. Thank you, Mr. Examiner. And so I have been retained by our client group specifically to take a look at how SEPA, the State Environmental Policy Act, has been handled for purposes of both this local improvement district process and the underlying set of improvements that basically form the foundation for the assessments that the examiner is looking at. Mr. Examiner, we've provided to you written materials already in the record, and we have several exhibits that we would be moving to enter. And I will address some of those in my comments today, and I would request the examiner accept that I would like to have a blanket admission of exhibits that I cite to in my materials, and I'd be happy to provide a follow-up list at the end of my comments if the examiner so desires.
No, so what we'll do is you'll need to, the exhibits will come in one at a time.
One
so
at a time?
Yeah.
Okay, I will go ahead and
Because the city
do my
has
best
to
to
have an
make sure.
opportunity to object.
Fair enough.
I would also at this time just ask to clarify, are you presenting legal argument or
about to-
fact issues here?
Thank
Okay.
you. I was just about to make that statement. Thank you. I am retained on behalf of the objectors as an attorney. I am providing legal argument. I am not a fact witness and do not intend to testify whatsoever as to the veracity of any facts. Those are being provided for through documentary exhibits and testimony by other witnesses. So I don't believe that I need to be placed under oath unless this examiner has a different impression of that. Thank you very much.
Could you please spell your name?
Yes. My name is Duana Koloshkova. My first name is Duana. And my last name is Koloshkova, Kolusko, V as in Victor, A. I am a licensed attorney to practice law in the state of Washington. I've been practicing law for more than 20 years. Entirely my career has been devoted to evaluation of land use issues, land development, and the State Environmental Policy Act. If you need a personal injury lawyer, I tell my clients I'm not the person to go to. Mr. Examiner, I understand that the examiner has provided us some time to provide legal argument on the topic of whether the State Environmental Policy Act has been complied with for purposes of this final assessment rule. And as part of my comments, I plan to address the examiner's jurisdiction in this matter, as we anticipate that's a critical consideration for the examiner to even open the door to review our concerns. But before I do that, I do want to lay the stage with a couple or a few exhibits that we believe are critical to our objection in this regard. As the city itself is well aware, the city performed some limited SEPA review for certain of the local improvement district improvements in 2016 based on a 2013 DS. That is the AWPOW FEIS. We live in a land of acronyms. That is set forth in Exhibit 7 of Objector's List of Exhibits, and I would move to enter that exhibit into the record.
I believe that exhibit's already been admitted.
So
Thank you.
It sounds like maybe you weren't prepared with exhibits.
Sorry, it's 6.
All right, so what
Oh, are we?
we have.
do have a list.
Right now, 30, 40 or more, yeah, well, no, we're all the way up, even beyond that, 59 is what we're on. So we've already got exhibits admitted.
Oh,
and I
those
need you
are
to-
admitted.
and
Okay.
Well, I'm talking about our exhibit numbers. We're not using the objector's numbers.
Right.
So if you
Okay.
reference Exhibit 7,
Got it.
I don't know
Thank
what
you.
you're talking about, unless you're talking about hearing
Thank you.
examiner Exhibit 7.
Thank you.
So you're going to have to work with co-counsel to identify what's been admitted already and what you intend to admit new along with your
Okay.
testimony.
Thank you very much.
So,
Mhm.
so do you have Exhibit 7 as the FEIS? That's what we have.
Yes.
Okay. Yeah, that one's admitted.
Okay.
And if you intend for me to follow along on any of those, you need to let me know. I don't know whether you're just going to keep going. It sounded like maybe you're just going to give a testimony, but I've got them all right here if you need me to be looking
I
at
do
something.
not plan to ask the examiner to look particularly at any of these exhibits,
Okay.
although there are a couple that I would pinpoint a page number to if the examiner will review when he's putting together his recommendations. But I don't plan to get into them in any depth. I think it's just setting the stage for purposes of the legal argument.
Mhm.
Thank you. So after that FEIS was concluded, there were petitions for review submitted and extensive settlement agreements reached, which the objector had listed as exhibits 57 and 58. And so I would move to have those in the record as well as part of the evidence of what SEPA review has been provided. But again, now I'm not sure how to reference those in terms of numerical order, or if those are just going to be new numbers assigned.
So what I need to ask you to do
Yep.
is, if you are in your testimony going to be referencing one of the objector's exhibits numbers, there were 1 through 57, I believe. Those numbers don't mean anything for the record.
I understand.
And
I
so
understand.
some of those have already been introduced, and you need to work that out with your
Okay.
co-counsel.
Yeah.
So
So
don't,
the-
I can't do that for you. We
No,
we weren't
I
tracking.
understand.
Yeah, she has your numbers here, and so, your exhibit number 57 and 58, which I believe we marked and tabbed yesterday for your records, but you had not yet admitted. So you-
Everything was admitted at the end of our.
Okay.
of our
Oh,
hearing.
great.
Okay,
Okay.
so,
Oh, no, these are the SEPA ones
Right,
that were reserved for
correct,
today. Sorry,
correct.
okay.
Yep.
So, we've got 400 objectors, so I really need you to let me know what
Yeah.
you're doing with your exhibits.
Yeah.
I can't keep
Absolutely.
track of all of them. So we've got 2 of them that you're seeking to admit now.
yeah.
All right, I
Your-
do need to pull those out then, so we can compare if there's any objection from the city. These are exhibits, numbers again, what?
Those are hearing examiner numbers 57 and 58.
Okay, thank you.
And you can go with 56 as well while we're at it, because it's all part of the
I think
background.
50, yeah, and 56, I believe, was already admitted.
Okay, all right. And the only one I really care about is 60.
That's the fourth,
Who's that?
that's the SEPA interrogatories, which have not been
Not marked
admitted or,
admitted,
ta-
so-
or tabbed yet.
So, having just been admitted,
Let me just take a copy of those.
He has in our tab note.
Great.
here.
Okay, yeah.
Okay,
that's
so everything up to
59.
56. is
Not
admitted.
60,
Okay.
okay.
Please mark these at your first earliest convenience.
Right.
All right, so yes, number 56 was admitted, and you're asking now about 57, 58. Any objection to the admittance of 57 and 58?
Yes, we object to the admission of these SEPA-related documents. The SEPA compliance issues that are being raised in argument are not relevant to this proceeding, which is limited in scope to whether the city's final benefit study assessment to particular parcels should be adjusted. And there's already a pending lawsuit that raises issues regarding compliance with SEPA, and this isn't the forum for formation arguments, which is what these arguments are.
So my guess is this is part of what your testimony is going to be addressing with argument. My suggestion is, rather than seeking to admit before you've made your argument, that we hear your argument and then seek admission and address this at that time, because the city's made its argument, but your response is essentially going to be the argument you're going to present anyway.
I think that's a fair summary. And to be clear, I am not testifying. I'm providing legal argument, and I do not plan to testify as to these specific exhibits. Just as that term keeps kind of raising its head in conversation. So yes, let me put a pause on the exhibits, and I will revisit my request for admission of those when I complete my legal arguments.
Okay.
And I appreciate very much everyone's understanding of my sort of popping in in the middle of these proceedings and trying to kind of figure out what my bearings are here. And I also appreciate the city's comments and questions as to essentially why are we raising these SEPA arguments in this venue. And the city is correct that we have also raised these issues with respect to our pending case in King County Superior Court. However, City Code is very clear under Chapter 2004 that objectors must raise any and every objection to the final assessment role that they may have. And if they do not raise that to this hearing examiner, and if this examiner does not make a recommendation, those objectors may be precluded from raising those issues upon appeal in the future. So it is somewhat disingenuous for the city to say, well, you can't raise this issue now in its argument and response, and yet say, but you may be precluded in the future from raising this issue if we stop you from raising it now. The hearing examiner's role in a local improvement district final assessment process is quite different, respectfully, from the hearing examiner's role in, say, an administrative appeal scenario or an original jurisdiction open record hearing for a plat or a master use project or some other entitlement process. And this hearing examiner, we understand, wears those different hats depending on the type of proceeding presented to him. Here, the examiner is charged with hearing all objections, ensuring that the record is adequate and that the city has provided the essential information for the private property owners affected by these assessments to be able to present their objections and concerns. The examiner must then issue findings and recommendations to council. This is not an appeal forum, nor is this an opportunity to argue with respect to any sort of other entitlement permit process. We recognize those processes are separate. However, as this examiner is charged with determining whether all the evidence has been sufficiently collected and the merits of the objections, the objectors have no choice but to raise all of their concerns and ask the hearing examiner to issue recommendations on those. And in fact, we do not believe that the city can artificially limit the objectors' legal arguments and testimony before this examiner or the examiner's recommendations on this point, as that would impermissibly also limit appeal issues in the future. And again, this all goes back to quite separate regulatory authority that the examiner operates under versus some other fora that the examiner often operates pursuant to. So, turning then to the question of whether SEPA review is a pertinent consideration for the final assessment hearing process, I'd like to first remind the hearing examiner, as I anticipate he's quite well aware, that SEPA is not intended to be a box to be checked off as part of a ministerial process of permit review. We have a long history of case law providing that SEPA needs to be addressed, reviewed, and thoughtfully considered at the earliest possible stage of the planning process. Now, the city has argued in its materials, and for one example of that is in its responses to interrogatories, which is set forth in Exhibit 59, that the LID process is categorically exempt.
Sorry,
Let's
just for the
pause
record,
minute,
I
there
will-
he
yep,
doesn't have that
yep,
is
one
no
and
reference
Exhibit
number.
59.
Yep, I just wanted to finish my sentence. So,
If you're going to be referring to,
and I am going to refer to,
if you'll be referring to objectors' exhibits, it will be helpful if you identify it as an objector's exhibit number or
Object-
something along
thank
those
you.
lines.
And
Because
I
if you
think-
simply refer to it as an exhibit,
Okay.
then someone listening to the record is going to get that confused between the actual record and your own numbers.
thank you. I am referring to Objectors Exhibit 59, and this will, I anticipate, be the only exhibit that I get into.
I'll get you the
I
tab
don't
number.
believe I've got a copy of that.
It should be tab 43 in our notebooks.
Sure. Oh, I'm sorry,
That's what, or you want-
no,
the actual document.
Yeah, right here, sure, we're looking at the same one. Can you turn to page 14?
All right, now in retrospect, what I'm understanding council was trying to do was identify this by a number that it was going to be marked with, is that correct? 59?
Correct.
Well, she did it,
Oh.
so let's let her
Correct.
do it. So that will be marked 59. We'll get to admissibility at the end of the testimony. So when I said objector's number, what I meant was the 43. I honestly don't know what you're referring
Thank
to when
you.
you just say exhibit. So, and I know that you're just figuring it out, and I want to make sure it's clear for the record.
And I hope we won't need to do this too many more times. I apologize to the examiner for a little bit of inefficiency here. Within those responses on page 14, there is an interrogatory number 44. And in that interrogatory, the city explains that it is its response that the formation of Waterfront LID number 6751 is categorically exempt from SEPA and refers to WAC 197.11.816. However, Mr. Hearing Examiner, as we've argued in our briefing, that categorical exemption 197.11.816 is quite different than other SEPA categorical exemptions that this examiner may be familiar with. That exemption provides that an LID is exempt unless that LID constitutes a final agency decision to undertake construction of a facility or structure. That's quite different than, for example, a categorical exemption for minor new construction. Let's say a short plat for 4 units, where there is absolutely no SEPA review whatsoever. This categorical exemption says certain LIDs may never receive SEPA review. That may be because the underlying projects themselves are exempt based on another provision of 197.11.800, or because they're an emergency. Neither of those circumstances are the case here. Or the LID may be exempt because it's not yet a final agency action. Again, we posit not the case here. Instead, Mr. Hearing Examiner, this categorical exemption does not operate as an umbrella for the city to delay, defer, or completely avoid environmental review of the set of LID improvement projects that are being used to assess this large group of private property owners with a very significant assessment value. Instead, the question is not, is the LID itself entirely categorically exempt? The question is, are we at the point of a final agency decision that in fact triggers or requires SEPA to be completed before that decision is made? And we believe, Mr. Hearing Examiner, that answer is yes. From the case law that we have cited to in our briefing, a final agency decision is not the very last permit or the building permit or the grading permit or the stormwater permit. That is one of the last decisions to be made by a given department in construction of a project. To the contrary, a final agency decision is that point in the project where a decision maker is going to be making a decision that will result in what the Magnolia Court has termed essentially a snowball effect, where there is going to now be a level of inertia that is generated by, for example, this council's decision such that the project is likely to carry forward irrespective of the environmental review that is performed later, and may well render review of a reasonable range of alternatives meaningless if that is delayed until after the council's decision. I'm referring to the Magnolia Neighborhood Council versus Seattle case. And in that case, interestingly enough, the city of Seattle argued, we don't have to do SEPA review until we get to the point where we're going to be zoning and performing entitlement work for the project, similar to what I might argue to this hearing examiner if I was representing a private property developer. And the court said, no, the Magnolia Neighborhood Council is correct that years before that, if you, city, are going to be making funding commitments along with the federal government related to how a property might be used, that is the time when you need to conduct SEPA. When you're making those commitments that might, at a certain point after that, snowball or have such inertia that you feel bound to continue with the project irrespective of what the SEPA analysis might reveal.
And Council, you've made reference to briefing. Am I going to get that?
Yes,
We provided the pre-hearing, or the hearing
It's
brief
part of the
on Monday.
pre-hearing brief. Okay.
yes, thank you. And all citations that I'm referring to are in that briefing.
Okay.
Thank you.
And we did, Your Honor, update it today to change the exhibit numbers to match your set.
Great, thank you.
So the question under Magnolia and the question under SEPA is not, are you conducting SEPA at some point, city, for purposes of the given projects, but are you conducting it at a time when it has meaning and value? And I would posit to the hearing examiner that the categorical exemption that language that relates to the LID is entirely consistent, or I guess inherently consistent with the rest of SEPA that says the purpose of this categorical exemption is not to simply say no SEPA review. It is to say if that LID is coming forward at the point where decisions are now going to be made with a snowballing effect that there is going to be inertia for the project, that is then the final agency decision for purposes of the LID. And because these projects have no other categorical exemption, this is then the time that SEPA must be completed before that council decision. And the way that the city's review of this project plays out is almost a perfect example of why that categorical exemption is written as it is, and why that categorical exemption is not simply setting up SEPA to be a checklist item for ministerial review long after funding commitments have been made. And yet, in this case, with these improvements, the city is going to essentially do exactly that if this examiner does not look more closely at the record.
You were referencing the categorical exemption and WAC 197.11.800, but
16.
16?
Yes.
Thank you.
Mr. Examiner, this final assessment role is the last decision point that the City Council will have related to these LID projects as a whole. Once we get done with this process, the city will proceed to stormwater review, construction review, maybe a shoreline permit individually for these projects. But there will be no other point whereby the city council is going to look at this project as a whole and make those policy decisions related to the projects. I would suggest, Mr. Hearing Examiner, that it almost boggles the mind to say that we can go forward to the city council and demand that property owners commit millions of private dollars to a project where there has been absolutely no SEPA review whatsoever of two of the major project components, being the Pier 58 Waterfront Park component and the Pike Pine streetscape improvements. None whatsoever. And some review of old versions of the other LID components. And in fact, in that EIS, the city recognized we should be doing cumulative review of all of these projects together. But then apparently, whether it's because of budget or time pressures or staffing, has changed its mind and said, well, actually, we can put SEPA off until we get to construction or building permit stage. That is not what this categorical exemption provides for, Mr. Hearing Examiner, and that is certainly not what WAC 197.11.055 mandates. This is not the earliest stage in the planning and permitting process. And to argue that SEPA can wait until after the city council demands that property owners commit millions of dollars towards a project because there's not enough information yet for SEPA defies logic, frankly. If there is enough information to demand that property owners commit millions of dollars to a project, then there has to be enough information to conduct SEPA. There's just no two ways around that. And if this is not the final agency decision, then what possibly could be? Under SEPA, the definition of a project action includes expressly decisions to fund activities, 197.11-704. Again, there can be no argument but that the purpose of an LID final assessment hearing is to provide funding commitments. Again, how can we ask property owners to commit money to a project and yet say it's not ready for environmental review, or argue that the cumulative impacts of those projects should not be addressed until months or maybe years later? By that point, the inertia will be much too strong. There will be far too many decisions made for SEPA to have meaningful review and for that cumulative impacts analysis to have any meaning or value whatsoever. There will be no opportunity for council to come back and revisit these decisions. These funding commitments will have been made. The final point I'd like to make, Mr. Hearing Examiner, is that there has, to the best of our abilities, we have searched for any sort of rational basis or legitimate public purpose to delaying SEPA for certain of the projects and sort of piecemealing it out the way that this process is doing. And to wait to conduct SEPA review for example, the Pier 58 Waterfront Park and the pipeline improvements until sometime unknown, excuse me, after the council makes its decision on this LID. And despite trying to understand what that purpose or planning rationale might be, we find nothing. The city has responded that, again, in Exhibit 59, Objectors tab 43 on page 14, that now it generally will begin SEPA when a proposal reaches 30% design, but provides no reason for that, no policy or regulation that supports such an assertion, and no explanation for how it could have done SEPA, performed a complete FEIS and entered into settlement agreements related to some of the projects, but yet do absolutely no SEPA whatsoever for the other half of these projects and still can complete assessments. There's just no logic to this process under SEPA, and certainly drastically violates the idea of conducting SEPA at the earliest possible time. So in sum, Mr. Hearing Examiner, if the examiner allows this process to move forward with a recommendation of approval in light of these SEPA violations, there can be almost no doubt that the inertia at that point will be so strong that the council will have no choice but to keep, and the city will have no choice but to continue the projects moving forward and use SEPA merely as a box to be checked off. Furthermore, there will be both planning, I guess I should say otherwise, the process risks planning delays, confusion as to what plans might change when, and would create a pretty significant question as to the validity of this LID process overall. If the answer is SEPA could affect these final assessments a year or two after the council makes its final decision and we'll just come back and deal with it then what is the legitimate public purpose in having such an inefficient process and demanding property owners to commit the funds that they're committing without having any actual security that the complete review process has been made in advance of, again, demanding them to make those financial commitments. So I thank you, Mr. Hearing Examiner, for hearing me out. I do want to make sure we move to admit the exhibits. I really apologize for some of the confusion on that. It makes for a little bit of an awkward presentation, and I will take a moment with my counsel to make sure that we have covered the exhibit entries. Thank you.
Council, you've referenced WAC 19711 816, and
Yes.
In part your argument is relying on the language of this WAC itself. Is there any in your briefing that, I'm not sure which exhibit that was, is there any reference to case law interpreting that exemption?
There is virtually no case law addressing that exemption. However, the case law that we do cite to addresses both the terminology that's used, the roles of categorical exemptions, and how SEPA needs to be applied in light of these sort of staged situations, recognizing that each LID and each of these major project processes are pretty different. It's I would say, almost impossible to find a similar, exactly same fact pattern throughout published case law history. There is an unpublished decision which I could supply the citation to, but it's from 2011 related to the Fremont Council case against the city of Seattle. But other than that, the bottom line is that this categorical exemption has had very little judicial scrutiny. And frankly, Mr. Hearing Examiner, I think that's because the point of this categorical exemption is pretty express, which is it doesn't remove the projects themselves from SEPA review. It's really trying to look at if you've got, for example, a pretty simple utility LID, I, as a property owner, then can't use SEPA to maybe get in the middle of that because the LID itself is not exempt. But here, the underlying projects by no means are exempt. They're absolutely subject to SEPA review, and the LID should not be used as a means to delay or avoid SEPA.
Thank you.
Thank you.
All right, so we have exhibits 57, 58, and 59. Can council state specifically what the purpose of these documents is being submitted for?
For Exhibit 57 and 58, there is an extraordinary amount of detail about the baseline conditions and the plans to be built, and the settlement agreements actually in and of themselves change the plan and make some agreement with them. And, yeah, and 36, which was already admitted, is just like one example for the Overlook Walk, because it continues to evolve and continues to change, and I think is yet again, according to Exhibit 26, going to be subject to more SEPA review itself. But in addition to just laying the foundation about what amount of SEPA has occurred and has not occurred, in addition to being fundamental to what's being built and what the plans and specifications are and the baseline condition, we find that those exhibits are really critical on that point.
Okay, so let me make sure, if you can summarize it maybe more shortly. Laying foundation for what SEPA's occurred.
Yes.
What else?
And being the baseline foundation for what the projects actually will consist of.
And that's for 57, 58, and 59?
No, just 57 and 58. And then 59 is the sort of status of SEPA review, the statements by the city of what the status is and what the plans are to deal with SEPA and the permitting and approval of the various projects at this point. We referenced Exhibit 59 in our hearing briefs. Actually, we referenced 57, 58, and 59 in our hearing brief.
All right. I understand the city's objected to these. Did you have anything further to add on that objection?
Well, I think that the hearing examiner has already admitted the Alpau FEIS into the record. I don't see why the petition for review of adequacy of the EIS would add anything. If the FEIS is the final EIS at issue and it's describing the baseline as you say, then I'm not sure why we need this additional document. And I would make the same argument about proposed Exhibit 58, which is an agreement, a settlement agreement concerning the Alpau. Again, as I understand, there's no dispute that SEPA review has been completed for the Alpau portion of the project. And if that's the case, then I'm just not sure what these documents add that would be of assistance to your review of the individual property assessments.
All right. Anything else?
Yeah, I would just add that it is in dispute whether or not SEPA's been completed for the various LID improvements that were included in the Alaska Way Promenade Overlook Walk FEIS. There are a number of not only internal inconsistencies within the FEIS itself, but there was no follow-up whatsoever from the settlement agreements to complete an SEIS, a supplemental environmental impact statement. And so we do have a number of concerns that these documents are one of the only windows into what the city has agreed to build, what the impacts of those improvements are going to be, and that they're the end of it. Yeah, I mean, they form the basis. That's the commitment to the LID. They're the foundation of what we're talking about here. What is the plan? What are the specifications? What are the impacts? Are they negative? Well, then there's not a significant increase in your property value if there's a lot of negative impacts.
All right. So I'm going to allow them to, at least in limited respect, because I understand that there's multiple objectors raising this issue. I'm not going to decide it based on an objection in the hearing. I'm going to allow objectors to make this argument, and then I will review what case law there is and the statutes that are applicable. And so to the degree that these are being admitted to lay a foundation for what SEPA's been done, whether SEPA's been not done here, something like that, I would allow it for that. The concern I have is that there's been something more than that described that I'm still not quite sure what that is. I mean, you started just talking about whether there's going to be negative impacts or significant impacts or not. That's not at issue here. This is not a SEPA appeal.
Right.
And so I'm not determining whether there's significant impacts or not. I'm letting you make the argument as to whether it's been done or not, and whether it's been done or not, it needs to be done or not. I'm not ruling on the substantive SEPA review that we're all used to in land use hearings.
Yeah.
And so, am I missing something that you're...
The biggest example I would point to is parking. And so there were a lot of inconsistencies and concern with the treatment and the evidence about parking and parking impacts. And one of the things that the documents help do in light of Anthony Gibbons' testimony that parking is so critical to the retail environment and so critical to the petitioners who had appealed, that's an issue where there's a lot of tension, there's a lot of confusion in the FEIS about what's really happening, and in the final special benefit study by Mr. McCauley that was just released last month, he mentions parking loss, sort of skims over it, attributes some impact to it, but doesn't go into any detail, doesn't itemize it, doesn't categorize it, doesn't map it, doesn't really tell us what's going on with the parking. And so I just offer you that is just like one example that's kind of an important one that the appraisers are using to base their testimony on, and that's been a pretty significant bone of contention with the retail and other people who depend on parking.
Okay, so I'm going to admit them for the limited purpose of laying a foundation for what SEPA review has occurred to support the objectors' arguments that SEPA should be done, and I'm not going to repeat your argument for you, but to support your legal arguments that have been presented today, but only for that limited purpose. I don't want to get into supporting of facts about what impacts there may be from the project, not only because I'm not ruling on that for SEPA, but because these documents aren't being submitted through a witness. They're just coming in for legal argument, and so they'll support the legal argument, and that's it.
Thank you.
Anything else?
Thank you.
Thank you. And what else do we have?
I believe we just have a short closing presentation.
Okay.
I think it's only like 10 minutes or 20 minutes.
All right.
Want
We're
to do
gonna-
that after the break? or-
Yeah, well, let's take a break for that. Let's return at 10:30. Is there anything else before we get to closing from the objector procedurally, or I believe we've admitted all of the exhibits we have in front of us? Anything from the sitting?
Oh, just going back to the hearing brief that was mentioned earlier, I'm not sure if that was admitted as an exhibit or just handed as a reference
I
copy.
sort of treated it like a pleading and just turned it in, but if you want to make it an exhibit.
I got a lot of papers, so I don't have any loose papers.
They file.
I have documents that were admitted as exhibits, so I don't know at what form or what time that was handed to me.
Were the pre-hearing briefs admitted with the objections, or?
No, we provided a paper copy on Monday.
We also
and-
filed it on
And then
Monday.
we filed it electronically, and then this morning we updated it electronically with the updated exhibit numbers.
Who'd you file it electronically with?
Galen.
You just emailed him?
No, I think we
Because we're not actually using our electronic file system
Yeah.
for this
Okay,
case.
so we,
Okay. So I don't know that we did that. I think we just emailed it.
we sent it by email to the same place we sent our objections, so.
Oh,
Oh,
probably
like-
just the LID
Yeah,
Mhm.
correct.
Yep.
mass mailing
Okay,
site,
so
yeah.
Maybe it would be more accurate for us to send an email to Galen with the correct case numbers? Is that a good way to get that?
Well, did you hand it in at some point physically?
Yes.
We did physically hand one in on Monday.
Okay. So we've got to have it here somewhere.
We have an
My guess
extra
is it
paper
was
copy
marked
of
with
the-
an exhibit
Do you have your?
And you're not referring to exhibits 1 to 3 that were part of your opening statement?
Correct.
Okay. Does it have an exhibit number?
No, I have the electronic copy right here.
Well, we need to know whether it's got an exhibit number or if it's floating around somewhere.
It does not have an exhibit number. We did not have it tabbed in a notebook, and I,
Do you have the case files? Just hand them to me.
I think those are front.
Oh, these weren't in front of me to begin with?
No, this came in on Monday.
actually, I think we refiled it yesterday.
You weren't here yesterday.
Yesterday.
So it just came in electronically, maybe? So these were with me here on Friday, correct? On Monday?
Yes.
Yeah.
So, they came in this. I can just print these out.
I'm mostly working. All it being handed forward. Okay. We don't seem to have a physical copy up here. It's not in your case file. It had been admitted as an exhibit, and would be the first time in my experience here that we simply lost a document. So, and I don't recall it coming in to me.
I just emailed you, Galen, directly, the updated one with the correct exhibit numbers.
Right, you will need to speak up for them. I can
I
tell
just
she's-
emailed Galen the updated hearing brief with the corrected exhibit numbers.
Okay. So I don't need that to have an exhibit number. It will be entered into the case file as a pleading.
Okay,
But I don't have a physical copy. We'll just print out what we've received.
okay,
And I assume the city's received a copy as well.
yes.
All right, with that then, we'll return at 10, anything else that we need to address? All right, we'll return at 10:30 for closing. Thank you.
Thank you.
And we return to the record to hear objectors' closing argument.
Thank you, Mr. Hearing Examiner. We've prepared a final closing slides similar to those that were admitted as exhibits 1 through 3, and we would ask that they,
both copies?
sure, that they get
You have 2
admitted
copies?
by
We
our.
just need one.
Okay.
And the city has a copy?
Yep.
Yes, and this would be, according to our calculations, exhibit 60.
That's correct.
I'll also say that for purposes of my closing statements, I'm going to be making reference to exhibits 31 and 42. And I just wanted to ask before I start, Exhibit 31, we substituted this morning a version that has actual page numbers on it so that you're able to follow it. So I want to make sure that that's the version you have for reference so I can refer to specific pages. The Exhibit 31, did you swap out the one that we provided this morning that has page numbers at the bottom?
Yes.
Okay, great. Thank you. Thank you. So we wanted to close this morning where we began, which is with Mr. Gibbons. You heard quite a bit of his testimony, and it's clear that you were following it and paying close attention, so I won't belabor the points. But, Mr. Gibbons identified 6 flaws in the Macaulay report. It does not measure or address the general benefits from the project, and thus its purported calculation of the special benefits necessarily includes and erroneously includes general benefits from the project. It does not, Mr. Macaulay's report does not accurately measure the before and after values, and it's It's unclear whether he has calculated the improvements that would already have to be made that are not part of the LID. And it assigns and does not measure special benefits. These are 3 flaws, just the first 3 flaws that Mr. Gibbons testified. Each one is a fatal flaw that falls outside the relevant professional standards. This isn't the inequitable treatment of vacant land and land values that could be fixed on a property by property basis. These are 3 fatal flaws, and we would suggest that this means the appraisal is invalid and can't be used. As it pertains to the properties at issue, I think it's telling that it's for me, it's quite informative to look at the different maps and to see how far we're talking about in terms of just proximity to the improvements and the properties that we're talking about. So if you turn to Exhibit 31, pages 12 and 13 purport to show the before and after lid conditions. And I just think it's telling to sort of flip back and forth and see, the sorts of improvements we're talking about and the scale. And Mr. Gibbons used these pages to prepare his Exhibit 42, which is where I would like to turn next. The first 2 pages of Exhibit 42 purport to show the King Street with and without the lid improvements. And again, these are the closest improvements to the 3 First Avenue South properties at issue here. And as you can tell, the properties are not even visible on this map. They're off the page. So these improvements are not in close proximity. There's going to be no improvement of the actual property at the First Avenue South buildings. And we heard from Mr. Ayers that we have no reason to believe that there will be any special benefits to the tenants currently residing in those properties. And the same is true for the next 2 pages of 52, which purport to show the improvements that are closest to the Courtyard Marriott property, 618 2nd Avenue. Again, Mr. Gibbons described it that the Columbia with lid, if you put a star under the C and the O in Columbia, that's approximately where the Courtyard Marriott is located. There aren't going to be any improvements made to the Courtyard Marriott. It already has sidewalks and trees. And we heard this morning from Melody Lanthorn, who, is very skeptical and in fact thinks that not only will the Courtyard Marriott not enjoy any special benefits from the LID improvements, she's concerned that the LID improvements will in fact suffer a special burden or damages relating to the lid. And you'll recall that Mr. Gibbons testified that is sometimes a thing that happens, that an LID can actually cause damages to some properties while at the same time specially benefiting other properties. And we would suggest that, the Courtyard Marriott may well be one of those properties. As for 255 South King Street, which is the Embassy Suites, again, looking at the last 2 pages of Exhibit 42, the Embassy Suites is not on this map. I would put a star on the O and the A in the railroad so that you know where 255 South King Street is. And the other point to note is that this map reflects improvements going further down King Street than is actually described in the narrative of the addenda. So if you'll refer to Exhibit 60, page 10 shows the different objectors' properties at issue. And this came from the, does this come from the addenda? Is that where the photo came from?
That is Exhibit B to the ordinance, the formation ordinance.
Okay, to Exhibit 14. But we have put the red line there is something that we added, because according to the text and the description of the actual improvements, those improvements stop west of where they are reflected on this map. Page 9 of Exhibit 60, I think, is instructive. This also comes from the addenda, which is Exhibit 31. And it purports to show the prioritized improvements that are being made to King Street. And it's very, very hard to read, but I can represent to you that the 255 Embassy Suites property is the last property referred to on the right, with the square right above the compass. But you'll see the LID improvements are in the pink boxes, and it appears that we are talking about 2 trees and a curb bulb. And as you know, the Embassy Suites assessment is a significant number that would not suggest that it would be required to pay for some curb bulbs and 2 trees. The assessment is $923,916. And there is essentially no evidence. Mr. Coons testified he does not believe, he has no reason to believe, there will be any special benefit to the Embassy Suites or its guests resulting from the lid. Neither the Embassy Suites nor the Courtyard Marriott advertise their proximity to the waterfront. In fact, the folks from the Courtyard Marriott don't even advise people to go to the waterfront. So we believe that there's just not going to be any special benefit to these properties. And finally, we heard from Christine Cole, who talked about the fact that the Embassy Suites and 255 have already spent millions of dollars to improve the public right-of-way, and they should be entitled to an offset for those funds, particularly given the fact that the improvements were A, required by the city, and B, they are nearly identical to the sorts of improvements that other property owners within the lid are receiving. And so our suggestion would be, to the extent there is an assessment against 255, that it should be offset by the several millions of dollars that 255 has already made. And I wanted to turn it over to Ms. Ducombe, who's going to talk about the last 2 sections of our argument.
And so this part begins on Exhibit 60, page 14, Your Honor. This is a recap of the fact that the plans and specifications are fundamental and missing. As Mr. Gibbons testified, these are critical to conducting any appraisal with any accuracy. The foundation and purpose of the waterfront LID must be fulfilled. The formation ordinance requires compliance with the January 2019 plans and specifications. The plans and specifications means 100% design, and they are not available. The city will acknowledge that. The plans and specifications and construction will not be complete for several years and remain subject to change according to the city. The plans and specifications are also driving, in large part, the costs of the various improvements and their value, which is in turn driven by percent of design. So the preliminary city appraisal, we know, relies upon percent of designs and costs to calculate the special benefit. The final city appraisal relies on percent of designs and costs to calculate increased values. Mr. Gibbons testified that the designs and costs are fundamental to the appraisal, and the city's appraiser certifies that the appraiser is accurate in this regard. The city's design, percent of design and cost estimation system that comes from CH2M Hill, 30% schematic design usually means about 5 to 7% designs. And then the concept designs usually means a design that's only about at the 2% level, and that reflects project definition issues still to be worked out. And we see that playing out definitely with the Overlook Walk, where major elements of the Overlook Walk have since been removed from the program since the formation ordinance. What we just figured out in the last week on page 19, going over the timeline, is that SDOT appears to have been fudging its percent of design. On the next page, in 2018, April of 2018, just prior to adoption of the resolution of intent to go forward with the Waterfront LID, the Office of the Waterfront presented to the Seattle Design Commission and represented that the Overlook Walk in particular was at 30% design. The Seattle Design Commission minutes reflect quite the opposite, that the Overlook Walk, despite all the effort and changes and work that's gone into the Overlook Walk, still remains only at a concept design stage, which is about 2% design. And the Seattle Design Commission noted a number of challenges with the current design and encouraged them to increase the elevator capacity, improve upon the stairs, and work more on the restrooms and the accessibility issues. And they also wanted to see more tribal presence and participation in the proceedings before the Seattle Design Commission. Unfortunately, this was at the exact same time that Mr. McCauley was certifying his appraisal for the preliminary appraisal. And while the truth hid in plain sight that the Overlook Walk was still only at a concept design level, Mr. McAuley certifies that the Overlook Walk is approximately 30% completed. But we know today that that's not true, wasn't true then, and appears going to page 22, it's still not true. So Mr. McCauley certifies in his appraisal that the Overlook Walk is 30% complete, that the Pike Pine Streets are something less than 30% and Pioneer Square something less than 30%. But then the city, in response to discovery, has been unable to verify that those numbers are true and has simply taken the position that it's something less than 100%. They're not done, and the real status of the plans and specifications today remains unknown. Moving on to page 23, this is the sort of the last section, which is again a huge foundational element for the Waterfront LID. The 6 specific projects, when you really pull back the curtain and you really dive into the details, are not offering very much, and certainly not offering special benefits. To begin with, as Mr. Gibbons testified, the central waterfront baseline is extraordinarily significant without the LID improvements. We've replaced the seawall, we've removed the viaduct, we've replaced Pier 62, there's a new 2-way bike facility, there's multiple new pedestrian bridges. We're, according to the main corridor designs, adding 823 trees, maintaining 453 parking spaces. We've rebuilt the historic Washington Boat Landing. We've built a Habitat Beach, and the main corridor itself was completely restored at a cost of about $370 million. It's really grand what's going on down there without the LIDs. The promenade, in particular, is a puzzle for me. They're actually proposing to remove and replace brand new sidewalks with exposed aggregate instead of the scored concrete that's going to originally go in, presumably this summer. They want to replace 110 trees with evergreens and 160 trees with ornamental trees, and then swap out one single type of ground cover with shrubs and bulbs. And they're only adding 16 trees. You know, that's what the final benefit study says, that we're only adding 16 new trees to the entire waterfront, 50 cedar benches, and then an unknown number of decorative planters. And then they are removing the on-street parking. There's just not a lot of there, Your Honor. And as we've noted earlier, there are significant code compliance issues with some of these items, in particular evergreens needing a lot more space than they're going to be given. The Union Street pedestrian connection, already there's wall art and a pedestrian connection, a metal staircase, and we're getting new art and a new staircase, but what's really the add here is the elevator. So Union Street adds an elevator. That's essentially what's going on. For the Overlook Walk, I think this one's gonna remain a mystery for a while. It continues to evolve, it continues to shrink. Unfortunately, while its elements are shrinking and its project definition are shrinking, what we just learned in the last week or two with the adoption of the city's capital improvement program is that the budget for the Overlook Walk has gone from $100 million to $174 million, while the elevators have been removed, the restrooms have been removed, and all the staircases but one have been removed. If you look on page 31, if you see that dotted line, though that dotted line area is outside the LID. So one of the reasons that staircase, it appears in looking at the drawings, won't make it into the LID is because it can't make the grade necessary to reach the bottom of the aquarium. So it is now contingent upon construction of the aquarium, as is the elevator. There are, as we noted with the Seattle Design Commission presentation, significant code compliance issues now with the Overlook Walk as a result of this diet I refer to. ADA access has been compromised, and Seattle Design Commission approval is still pending. Pier 58, on page 33, really, I think highlights how far away we are from knowing what we're doing and how long we have to go. And in purposes of being able to do your SEPA at the earliest point in time and keep all options on the table, it is, for me, probably personally, one of the most frustrating elements of the project, because restoration of the shoreline and the natural habitat have just been summarily removed from the options, and it's just very unfortunate in this environmentally friendly city that that's what we've chosen to do. Pier 58, by the city's admission, needs an enormous number of environmental review and permits and projects. That's Exhibit 26 in your exhibit, Your Honor, and still lots of work to do there. The Pike and Pine Street improvements aren't as are clearly a mile or more away from the properties here at stake in this arena, but I would just point out that, I think especially when you look at page 36, there's just not a lot of difference between the before and after scenario. We're taking existing planters and we're putting them in the ground, and we're decorating crosswalks and planting a couple trees. It's not really something that you would expect from a local improvement district that really focuses on physical improvements and actual improvements to an area. And these improvements by no means are benefiting the properties in Pioneer Square. And then I did want to just spend a minute or two on the Pioneer Square streets. I think Mr. Williger hit this really well. There's the improvements slated for there are extraordinarily modest. The diagrams and the addenda misrepresent or are inconsistent, I will say, to give the city the benefit of the doubt about what they're actually proposing to build and what they say they're going to do. They show a diagram with dozens of trees and new this and that, but when you get down to the actual plan, it's 2 trees and a curb bowl for King Street. So it's really modest. It's not something that warrants $1 million assessments, and it's not something that's adding any special value whatsoever to Pioneer Square. In closing, there are also, as Ms. Koloskova opined today, and as we've set forth in our hearing brief, a handful of validity issues, procedural defects, and other challenges with the LID, the way it's come together. And we're asking Your Honor to find that those are things that do need to be cured prior to adoption of the final assessment roll, and we're looking for a recommendation from Your Honor, like with all these challenges and these objections, to make sure this work happens before the final assessment roll is finally adopted by the City Council. And that's it.
Thank you, Council.
Thank you.
Anything further from
Not
objectors?
from us.
Anything from the city?
No.
All right. I do want to return back to you notebooks with exhibits that
Sure.
we did not use. Let me make sure I'm not handing you mine.
Ours probably have white tabs on the outside. Thank you.
Any objection to Exhibit 60 being admitted?
None, thank you.
60 is admitted. I think everything's been admitted then. Thank you. We will conclude this portion of the hearing and reconvene on March 3rd at 9 a.m. Thank you.